Glennon for writing this really remarkable book, Free Speech and Turbulent Freedom, that we're here to discuss and debate and celebrate today. I'm Josephine Wolff. I teach cybersecurity policy here, and I direct the Hitachi Center for Technology and International Affairs. And I'm not a lawyer. I'm not an expert in free speech. I thought this was an incredibly fascinating book, a brilliant book, and also a really beautifully written book, one that takes us from Ralph Waldo Emerson and Walden Pond in Concord, Massachusetts, to Mark Zuckerberg in Menlo Park, that traces the history of the law of the First Amendment, but also the history that's very near and dear to my heart of the global expansion and spread of the internet, the rise of the major social media platforms, and understanding how those platforms have transformed the ways that free speech is being interpreted and applied in the United States and all over the world. It's also a little bit of a cautionary tale for me about technologists, computer scientists, software developers who dabble just enough in law to be dangerous. And as a computer scientist who dabbles a little bit in law, I'm going to keep my remarks very brief. Not least because I am, of the 5 people you see up here, the one who knows the least about free speech by a very, very large margin. So I want to thank the wonderful panelists that we've gathered here today. Starting on my far left, we have Thomas Healy, who's a distinguished Board of Visitors Professor of Law at Seton Hall, and also the author of The Great Dissent, How Oliver Wendell Holmes Changed His Mind and Changed the History of Free Speech in America. Next to him, we have Nadine Strossen, the former president of the American Civil Liberties Union, and also the Harlan Law Professor Emerita at New York Law School. Our own Michael Glennon, the Professor of Constitutional and International Law here at Fletcher. And finally, Bob Cordy, the former Associate Justice of the Massachusetts Supreme Court. You're going to hear from all of them much more than I can offer. I want to give a few introductory remarks about what it meant to come to this book as a technologist, thinking about this from the perspective of the internet, because this is a book that traces a much longer history than the history of the internet, but that is set against the global rise of the internet, and along with it, the major social media platforms, and that tackles some of the hardest questions that have been coming up since the beginning of that relatively brief history of the internet. So if we go back as far as 2000, which in internet years is a very long time, the site that it was and is still Yahoo, but ran a kind of auction, eBay-like function at the time, ran into a big problem in the French government, because they were allowing people to auction off Nazi memorabilia, which was illegal in France. And Yahoo felt they had resolved the issue because they had taken that Nazi memorabilia off of the French version of Yahoo. And so they felt they were respecting France's laws on the French version of their website, and several organizations in France felt that was actually just a farce, because anybody in France could go to the US version of Yahoo and access that same material that was illegal there. So they were sued in French court, where they lost, and they were told, if you want to continue doing business in France, you have to block this material from any IP addresses that are being geolocated to France, from anybody who identifies their own address as being within French borders. And then Yahoo did something kind of wild, and they went to court in California, and they said, the French court is trying to abridge our First Amendment right to free speech. They're telling us what we can put on a US website. And they were sort of setting themselves up for the really profound problem at the heart of the internet, which is that if you have a global internet with a set of information that everybody all over the world can access, it's really hard to respect everybody's different laws around free speech. And then they kind of backed off and decided, actually, we're just going to take all the Nazi memorabilia off every version of the website. And this book is a little bit about, to my mind, that same phenomenon repeating itself as the internet grows, as the platforms get bigger and bigger and more powerful, as they expand to more and more countries, not just to France and to Western Europe, but to Asia, to Africa, to all of the places that are really coming online in a major way over the course of the past 10 to 12 years. And the thing that sort of struck me most, the thing that I thought about and was most disturbed by and most moved by in reading this book, is that the fundamental underlying protocols of the internet, the technical architecture of it, which says you can hide what IP address your computer is coming from. That is fundamental, integral to the nature of the internet. is a real problem when we think about what does it mean to respect different free speech regimes around the world. And it's a real problem in my world as well. As you can perhaps imagine, if you can hide what IP address your traffic is coming from, it creates an enormous number of security issues that I spend a lot of my time and energy working on. But one of the things we tell ourselves when we're working on some of those security issues is these designs are really important, really seminal for a lot of other reasons. So we have to find ways to tackle the security challenges. And one of the things we've sort of traditionally thought they were good for, these very sort of flexible or adaptable, resilient architectures that allow you to route internet traffic through other servers to look like you're coming from France or look like you're coming from the United States just by hopping through another computer. One of the things we think they're good for is freedom of expression, because they make it really hard for governments to effectively control speech within their borders, right? You can impose, and some countries do, a lot of restrictions on what online traffic you allow to a certain set of IP addresses allocated to your country, but people can use very popular, very easily accessible tools like virtual private networks, like proxy servers, to evade those protections. So in my mind, and I think for a lot of computer networks people, these protocols are supposed to help promote free expression. And what I really realized reading your book and sort of watching you trace the history of how that global expansion has meant that platforms more and more take that Yahoo approach of saying, okay, if this is something another country is going to object to, if this is something where we're going to run into problems with any of the countries where we do business, maybe better just to take it offline entirely and not try to deal with this question of which country is it going to be legal in, which country is it not going to be legal in, when we can't even really effectively enforce only people in the United States can see this content, only people in this other country can see that content, because people can hide what country they're coming from, then maybe those protocols, maybe those design decisions, which are really near and dear to my heart, which have totally transformed the entire nature of modern communications, are not just posing serious threats to security, but also in some ways posing really serious threats to free speech. So, having told you what I think your book is about, let me pause. Let me turn to you and ask you to talk a little bit about why this title, why this book, what made you want to write it.
Josephine, thank you very much for those kind words about the book. And let me say a few words of thanks before turning to Josephine's question. Thanks to all of you, first of all, for being here today. And thanks to our hostesses, Ellen McDonald, our sensational new library head. I think this is her first major event. Ellen, thank you very much.
Signaling you to speak a little louder.
I'll try. I said, thank you, Ellen. Josephine is the most amazing multitasker that I've ever encountered. She seems to do everything around here, and she does it with consummate skill. She's devoted hours to planning this event, and I just can't thank her enough. I mean, it's the nicest gift you could give to an author, to surround him with old friends and colleagues and students to get the book off to a good start. So, Josephine, thank you very much. And I want to thank each of our panelists for being here today. Thomas Healy, I just met a few minutes ago. He is the author of a riveting book, The Great Dissent, on the chance meeting on a train between Oliver Wendell Holmes and Learned Hand that caused Holmes, whom you'll hear more about in a minute, to change his mind and ultimately become the father of the modern First Amendment. Nadine Strossen, my old friend and fellow Minnesotan, I think it's fair to say, is quite arguably the most eloquent and knowledgeable and certainly active defender of free speech in America today. Thank you, Nadine, for being with us. My old friend Bob Cordy sat for 16 years with great distinction on the Massachusetts Supreme Judicial Court, occupying the seat once held by Oliver Wendell Holmes. And I would be remiss not to mention Josephine again, who has in a very short period of time become one of the nation's foremost authorities on cybersecurity. So thank you all for being with us today. It's really an honor. And thank you to the Hitachi Center and Carolyn Gideon for providing research assistance, support to the Fletcher students who worked on this book. I think that's everybody. Now, let me turn to Josephine's questions. The title of the book comes from a line of Ralph Waldo Emerson, the great American public intellectual of the 19th century, who wrote the following words in the run-up to the American Civil War. Quote, "Citizens of feudal states are alarmed at our democratic institutions lapsing into anarchy, and the older and more cautious among ourselves are learning from Europeans to look with terror on our turbulent freedom." Unquote. I wrote this book because I'm alarmed. I'm alarmed at the broad-based assault on freedom of speech in this country. And I'm alarmed by some of the arguments made against free speech by people who should know better. I want to consider very quickly, because I want to hear the other panelists and your questions, I want to consider very quickly three of those arguments and conclude by recalling a student from Emerson's times whose intellectual journey may have something to teach all of us. First, opponents of free speech argue that suppressing free speech is necessary to preserve democracy. They view free speech as kind of an optional add-on. They think you can have democracy without free speech. I wrote this book to suggest that these people are profoundly and dangerously wrong. Freedom of speech is the lifeblood of democracy. You cannot have democracy without freedom of speech. How can voters possibly make informed, intelligent choices if those choices are based entirely on what the government permits them to read and hear and think? Elections without free speech are a charade, a sham. No, both democracy and free speech rest on the same premise, and the premise is that people are able to sort out for themselves what's true and what's false, what to think or feel or love or hate is for the individual to decide, not the government, and that individuals are able to decide for themselves what is in their own best interest. If you don't believe that, you don't believe in either democracy or free speech. A second argument that opponents of free speech make is that much speech is harmful. It's hurtful or false, and it has no political value. So why not ban it? To which I reply, because trying to suppress it creates even greater harm. The effort to suppress it menaces stable government, just as Brandeis said. It menaces stable government. Why would Brandeis have said that? Well, pause for a moment and think about the consequences of censorship. We know what its effects are from lots of historical experience in many countries over many centuries. Censorship discredits the censors, who are seen as patronizing elites. They inevitably go into overkill and silence or chill speakers whose words we need to hear, usually critics of the government. Censorship demeans listeners who are told that they can't handle the truth. It makes martyrs and heroes out of the censored. It gives their messages a forbidden fruit quality, making them more attractive and sought out. It drives their speech underground, where it's much harder to rebut. It robs oppressive minorities of the tool that is most essential to escape their oppression. Suffragettes, civil rights leaders, LGBT activists, all relied on free speech to get their messages out. John Lewis, the great civil rights leader, said that that movement would have been a bird without wings had it not been for freedom of speech. Who seriously can believe that censorship today would benefit the weak more than the powerful? So it's not that no speech is harmful. No, it's that trying to suppress speech causes greater harm. It menaces stable government. Third, the government and social media platforms argue that their censorship is constitutionally protected. Many Americans don't realize this, but they have joined together to create what is arguably the most massive attack against free speech in United States history, which has had the intended result of suppressing millions of protected free speech postings by American citizens. Those are not my words. Those are the words of two federal courts in a landmark case that is now before the United States Supreme Court. The social media platforms argue in this case that they're private actors. So when they exercise editorial judgment in content moderation, they're not subject to First Amendment constraints because the First Amendment limits only the government. The government argues that its own speech, its recommendations to the platforms, is also insulated from constitutional constraints because government could hardly promote its policies if it were limited, say, by First Amendment viewpoint neutrality requirements. Therefore, both the government and the platforms claim that they are speakers whose speech is protected, even if the purpose and effect of their speech is to curtail the speech of others. My own view is that their speech is protected, but only up to a point. They are not the only participants in the digital public square, which is where the marketplace of ideas now exists in contemporary American society. Users of social media, listeners, and the general public also have free speech interests. And protecting the free exchange of ideas requires balancing and reconciling all those rights in a new framework adapted to the digital era, which is primarily a job for the courts. Primarily, but not entirely. I'm going to conclude with this thought. Every one of us can do our part. We can do our part by approaching public discourse with a little more humility. We can recognize that none of us is infallible, and that people who disagree with us may have something to say that's worth hearing. I describe in the book the intellectual journey of a young student who had a very keen sense of social justice. He ultimately became the most respected Supreme Court justice since John Marshall. He was from here. He was a disciple of Emerson. His name was Oliver Wendell Holmes, Jr. Holmes left college to go fight against slavery in a civil war that killed 600,000 people. He was seriously injured several times. He almost died. He never regretted doing that, but when he returned home, Holmes had an important new insight, and his insight was this: there is more than one legitimate vision of social justice. And it's dangerous to believe that any one of us has unique access to ultimate truth, that our adversaries are the physical embodiment of evil. This delusory certitude, Holmes believed, leads inevitably to violence. It leads to violence because if you know with complete certainty that you are right and your opponent is wrong, there's no reason to allow that person to speak. And because that person may think the same thing, that leaves violence as the only alternative. Sometimes violence is the only choice, as it was for Holmes. But surely, we ought not choose the road to violence while the alternative remains available. I wrote this book and I dedicate it to my students to urge that we embrace the alternative, a vibrant, open, robust, decentralized, independent marketplace of ideas in which the speech freedom of all participants is not only respected, but protected by the courts under the First Amendment of the Constitution of the United States. Thank you.
Thank you so much, Michael. I'm going to come to each of our panelists for some remarks and sort of your responses to the book, and then we'll open up to questions from all of you. Thomas, let's start with you.
Thank you so much, Josephine. And Michael, thanks so much for inviting me to participate in this event. I'm honored to be here with the other panelists and to have a chance to comment on the book, which is really phenomenal. You should be extraordinarily proud of what you've accomplished, and your remarks were really moving. You have a way, both in the book and in your comments here, of distilling pretty complex ideas into some very simple and straightforward and very difficult to disagree with propositions. And I'm generally not going to disagree. I might disagree just a little bit about some minor things, but I'm not even sure that they're things that Michael's advocating for. But one of the things that struck me in reading the book, and Michael sort of acknowledges this in the preface, is that it's in some ways more than one book. It's 3 books. Maybe you plan to write 3 books and then
Afterwards.
So the first part of the book is really about how our modern understanding of free speech developed, and it revolves around Oliver Wendell Holmes Jr. and his conversion, I guess we might call it, on the issue of free speech 100 or more years ago, during and right after World War I, when the country was in another period of turbulence and strangely, coincidentally, facing a pandemic. One of the really sort of odd ways in which history is rhyming with itself in this present moment. And Michael explores Holmes's development, introduction of the concept of the marketplace of ideas, which is something that he introduced, that he developed. It was not a way that people had thought about free speech prior to that point. He does a fantastic job sort of explaining what the marketplace of ideas is and what it means. And I'm going to talk about that in a moment, but he then addresses the question of whether that understanding that was developed 100 years ago to address the problem of government censorship, whether it's still relevant today in an era in which I think many people feel as though the primary threat to free speech is not overt, direct, sort of clumsy government censorship like the Espionage Act of 1917, but more subtle, covert forms of censorship, many of which emanate not from the government but from private actors. And this is the source of the debate about cancel culture in recent years and political correctness before it, the sense that the biggest threat to free speech is not the government passing laws and putting us in jail, but other people responding to our speech in ways that inhibit us, in ways that chill us, and that ultimately undermines the marketplace of ideas. And I think what Michael is trying to do here is to make an argument that understanding, the marketplace of ideas, is just as relevant to the current challenges we face to free speech as it was 100 years ago or more when Holmes introduced the concept. And so in that sense, as I said, the book travels across time. And as Josephine pointed out, you spend the first third or so of the book, in Concord with Emerson and Thoreau, and it's lovely. It's like a period film, and written really beautifully with great details. And then you've got young Oliver Wendell Holmes Jr., who looks up to Emerson, but ultimately comes to disagree with him. And then we move as the book proceeds into the present, where yes, we're dealing not with Emerson and Thoreau, but Mark Zuckerberg and oversight boards and things that Josephine likes to spend her time on that I don't, frankly. But they're important. They're important. I prefer Concord and the 19th century. But I think what's great about what Michael has done is to bring these two worlds together, and in a way that not a lot of free speech scholars do. I think those of us who are interested in the history of free speech like to stay in history, and then those people who are interested in sort of the modern pressing what's the problem on the agenda today tend to like to stay in the present and think about the future. And what you've done, I think, really admirably and beautifully is to try to bring those two worlds together, and so I commend you for that. And in trying to do that, I think what Michael is trying to do is make a case for the marketplace of ideas and why it's still relevant. And in order to do that, you have to understand, well, what is the marketplace of ideas? What does it mean? Why do we put our faith in the marketplace? And one of the things I love about the book is that I think Michael successfully pushes back against a misunderstanding of the marketplace of ideas. There is a sense among, I think, some critics of the marketplace of ideas that the idea is that it's supposed to magically produce the truth. And if we just trust the marketplace, yes, we will find the truth. And they look around and they say, well, we certainly haven't found the truth. large swaths of the population that believe clearly false things, so the marketplace is failing. And I think the point that Michael's trying to make is that's not how Holmes envisioned the marketplace. Holmes didn't envision that the marketplace would guarantee us the truth. What he argued was that it was the best of the alternatives. It's really a comparative claim that's being made on behalf of the marketplace of ideas, and Michael makes this point by, I think, referring to a lawyer, a law professor that you knew who always asked about legal rules compared to what, as compared to what, right? And I think that's the question we have to ask when we're talking about the marketplace of ideas, as compared to what. And the way that Holmes envisioned the marketplace working, or the reason he thought that it was a useful way to think about free speech, is because he was skeptical that any of us could find the truth. And why was he skeptical of that? He was skeptical of that just because of common sense and because of history and experience. If you look back over our history, if you look back over your own personal history, you might be not too surprised to find that you've been wrong about things and that we as a society have been wrong. And so that's the starting premise of the marketplace of ideas, is skepticism. Skepticism in our ability to know the truth at any one moment. And if we accept that proposition, then I think what Holmes is saying is, in light of that inability to know the truth, how can we act? How can we move forward as a society, and how can we do so safely? That's a word that's in Holmes's a dissenting opinion of Holmes that Michael points out, and I think rightly. Holmes's argument is that in the face of uncertainty, in the face of our humility about our own ability to know the truth, how can we make decisions? How can we move forward safely? We have to make decisions. We have to decide what policies to embrace as a society. And so how can we do that? And his argument, and it's really just a very simple, straightforward argument, is, well, we can act safely as long as we have scrutinized the ideas that we're acting upon, as long as we have subjected them to critique, as long as we have given the other side a hearing. If we haven't given the other side a hearing, if we have blocked those people who disagree with what we're doing from speaking, then we can't have safety or security in the decisions that we're making. Now, we may still be wrong in the decision we make, but at least we will have made it after doing everything that we possibly could have done in order to determine whether it's the truth. Holmes said once that he defined truth as the system of his own limitations. He said, truth, for me, are the things I can't help believing. Right? And what he means by can't help is that he's done everything he can to try to figure out what the truth is, and at the end of the day, this is what he can't help but believe. And I think as a society, that's how we should think about free speech and our pursuit of truth. Have we done everything we can to say that these are the things we can't help but believe at this point, and we're going to move forward? But if we've blocked speech, then we're not in that situation. We can't say that we have done everything. And this is the understanding that has really guided free speech over the last 100 years. It's the basis for the principle of content neutrality, which says that the government can't choose among ideas, that the government, at least when it's regulating speech, has to remain neutral. It can't put its thumb on the scale, it can't tilt the playing field, because to do so is to deny us the benefits of the competition of the market. And I think, I think the marketplace of ideas metaphor has successfully helped us to answer difficult questions about free speech. Should we protect speech that advocates violation of the law? Should we protect speech that's offensive? Should we protect speech that we think is false? And at every point, the court has said, well, any other choice would require the government to say ahead of time, this is what's true and this is what's false. And the whole point of the marketplace of ideas is you can't do that. Because if you've done that, then you've cut off the very process that we're relying on to act safely. Where it has become, I think, complicated in recent years is when we talk not about the government taking sides and the government discriminating against speech, but when we talk about private actors in society taking sides and discriminating against speech. And here I would argue, and I don't think that Michael or anybody here would disagree, the situation is entirely different because we all are participants in the marketplace of ideas. We don't stand outside the marketplace. We are the ones inside the marketplace who are debating, who are critiquing, who are exposing ideas that we believe to be false. And so rather than be neutral, rather than just walk around saying, well, I guess every idea is fine, we actually have to use our own voices to counter speech that we believe to be false. And this is the premise of Supreme Court case law. We don't rely on the government to counter speech that we think is harmful. We rely on our speech, right? So when people with a broad brush condemn all aspects of cancel culture as being inconsistent with free speech, I think it's really important to distinguish what they mean. If we're talking about criticizing other people's ideas or even condemning harshly, vehemently other people's ideas, or shaming people who have ideas that we disagree with, or trying to discredit them or trying to marginalize their ideas, or not personally giving a platform to ideas that we think are dangerous, in my view, that's all perfectly consistent with free speech. That's really a part of the turbulent freedom that we have. And so, on the one hand, we've got the government that is supposed to remain neutral, so the marketplace can function. And then on the other hand, we have all of us who are in the marketplace, who are fighting over these ideas, right? And you do fight over ideas, and it's important that you do. If someone is out saying that children should eat lead because it's good for their health, you better believe that health professionals are going to do everything they can to expose that as false and to marginalize that view and to not give a platform to that view, and rightfully so, in my view. Now, where it gets super complicated is with social media platforms. 1 minute? Okay, I'll just end it. Because social media platforms arguably occupy a sort of third position because of the power that they occupy. They potentially are not mere participants in the marketplace, but potentially have the ability to control entry into the marketplace in ways that we worry about when the government does it. And I think Michael's big concern is when social media platforms and the government team up to do that, as I think he argues very forcefully they have in some circumstances. Then we sort of have the worst of both worlds: the sort of the government censorship and a private actor leveraging power in the marketplace in a way that frustrates the marketplace. The how we answer that question or what we do about this complication is very difficult. The Supreme Court is this term going to decide 2 cases that address this specifically. In one set of cases, states have prohibited social media platforms from moderating the content on their platforms, right? And that's obviously something that we would never allow a state to do with respect to us or with respect to a newspaper. And the question for the court is, are social media platforms so powerful and do they have sort of chokehold control over the market that the government has no choice but to tell them that they cannot moderate the content on their platforms. And the other case is the case dealing with the issue that Michael spends a lot of time discussing in the book, which is when government encourages / coerces social media platforms to regulate content on the platform. Very difficult questions, and I think, to Michael's credit, he resists the temptation to dig too deeply into the facts of any particular case and the doctrinal niceties that are going to decide these cases. I think what he wants us to do, and I think I agree with this, is to keep our eye on the larger picture, on the idea that if we're going to move forward safely as a society, that we need to make sure we've done everything we can to vet the ideas that we have before we make decisions based upon those ideas.
Thomas, thank you so much. Nadine.
Great. Well, thank you so much. I speak constantly, and I'm wearing out my voice. So in order to project, I'm going to stand up, and also so that I can see everybody. And if somebody who is near water could pass me a glass of water, I would be very, very grateful, because I predict my voice is going to run out. Michael, you know that I have been a free speech evangelist full time since 2018, no exaggeration. I speak about 200 times a year, and I never, ever write out my remarks. But I did that in a tribute to you. This is really a special occasion because we were given, thank you so much. Hey, how great to see you. Protecting my free speech. Facilitating it. We were given very strict time limits, and I wanted every single word to count. So I didn't want to depend on extemporizing. That said, I can't help myself. So one of the things that Michael said, I really want to underscore, especially because here we are in Black History Month. Here we are in Boston, where the great, eloquent abolitionist leader Frederick Douglass gave a very famous speech in 1860 after an abolitionist meeting had been broken up here in Boston. So for people who get smug about, it can't happen here, it did. And one of the lines that Douglass uttered, I put right up there with that great quote from John Lewis, and it's completely typical of every advocate of every movement for racial justice and for every other human rights cause throughout our history. They have all robustly depended on a very invigorated concept of free speech and have acknowledged that censorship, even censorship that's intended to protect them, to protect their causes, is ultimately dangerous to those causes. So what Douglass said was slavery cannot abide free speech. 5 years of its exercise would banish the auction block and break every chain in the South. So I am so grateful to you, Michael, and I decided, to expand my knowledge by really wonking out on the constitutional law issues that you presented. The book makes many crucial contributions to our understanding of current threats to free speech, and I'm going to focus on the one that I consider especially salient. Namely, the book examines two major, recently developing constitutional law doctrines that do not directly affect freedom of speech. But as Michael shows, these doctrines have an outsized practical influence on how much free speech we actually enjoy or don't. These two doctrines aren't even directly related to each other. So Michael has been especially insightful in discerning their insidious interrelationship in the free speech context in particular. The two doctrines are first, the government speech doctrine, and second, the entanglement doctrine. In particular, Michael shows the pernicious impact on online speech, online free speech, when the government takes advantage of an unduly expansive view of the government speech doctrine combined with an unduly narrow view of the entanglement doctrine. The upshot has been the government's suppression of disfavored dissenting ideas and speakers from the crucially important online platforms by coercing and colluding with the platforms, even though the targeted expression is undeniably constitutionally protected. In other words, the First Amendment clearly bars the government from directly censoring the expression at issue. Nobody debates that. That is precisely why the government has to do a First Amendment workaround, which again it does by invoking distorted versions of these two key constitutional law doctrines at issue. Now, these doctrines have been fairly obscure, even among many constitutional law experts, so let me take a moment to explain them. Again, this is a major reason why Michael's book is so important, because it has unearthed these doctrines from their relative obscurity, and it shows that their harmful impact has been enhanced by the extent to which it has occurred below the radar screen. So I'll start with the government speech doctrine. Given its label referring to speech, you might expect it to be a speech protecting doctrine. To the contrary, though, the doctrine which the Supreme Court recently invented vested government with new power to suppress speech. In 2009, Supreme Court Justice John Paul Stevens commented that the court's decisions relying on the recently minted government speech doctrine have been of doubtful merit, close quote. Alas, the very next year, the court issued yet another such decision of even more doubtful merit. Now, as I indicated, the problem was not in the basic concept at issue, but rather in the court's dangerous expansion and distortion of that concept. The basic common sense concept is that government officials have their own First Amendment free speech rights, including their right to comment on matters of public concern, which have always been of paramount First Amendment importance. Indeed, one could plausibly argue that government officials have a responsibility to comment on such matters, and the rest of us certainly have not only a First Amendment right to hear such comments from government officials, but also a vital interest in doing so. So when it comes to actual expression that actually comes from the government, it sensibly is not subject to any First Amendment constraints, not even the core viewpoint neutrality principle that both Michael and Thomas have referred to. The court has called this viewpoint neutrality principle the bedrock principle underlying our First Amendment case law, that when government regulates what we, the people, say, it must do so in a viewpoint neutral fashion, neither favoring nor disfavoring any viewpoint or idea. But when the government itself speaks, it would be nonsensical and dysfunctional to hold its speech to the viewpoint neutrality principle, as Thomas explained. Officials are free to advocate whatever their preferred public policy positions are without having to give equal time to opposite perspectives. For those of us who don't like what the officials are saying, we have the same remedy as we do when we don't like what the officials are doing. We can lobby against their positions and policies, or we can vote them out of office. But here is the problem. Starting in 1991, the court's newly minted, expanded version of this doctrine has turned it inside out, from a concept that is fully consistent with and supportive of free speech for all of us to a concept that licenses government to suppress our speech even on a viewpoint discriminatory basis against our speech. The court has achieved this reversal through two basic moves. Michael focuses very presciently on the second one, but let me start with the first. First, the court has mischaracterized certain expression as attributable to the government rather than to private individuals. For example, it upheld a federal law banning doctors at family planning clinics from accurately answering their patients' questions about abortions simply because the clinics received some federal funding. Contrary to common sense, as well as to free speech concerns, the court asserted that the speech was not the doctors, but rather the government's. Hence, the court upheld a regulation that violated the most fundamental free speech tenets, including not only the viewpoint neutrality principle, but also the right to be free from government-compelled speech. The regulation barred any doctor or other staff member from making any reference at all to abortion. And even if a clinic patient on her own initiative asked about abortion, these medical professionals were barred from saying anything except they were required to mouth a government-dictated script. And the script is, this clinic does not consider abortion an appropriate method of family planning and therefore does not counsel or refer for abortion, period. Critiques of the overly expanded government speech doctrine have focused on this problem with it that I've been discussing, that it wrongly designates private speech as government speech, and hence it excludes such speech from even core First Amendment protection. Michael, though, has presciently spotted a second special danger of the overblown government speech doctrine. And Michael, I told you when I first read this, to the best of my knowledge, you're not only the first person to have spotlighted this, but to my knowledge, the only person. And it's a very, very important contribution. And that is that this doctrine is invoked to protect expressive conduct by government officials that goes beyond conveying viewpoints, and that instead conveys credible threats of adverse government action. In particular, Michael has highlighted governments invoking of this doctrine to threaten social media companies if they don't deplatform expression that dissents from government policies. But in our democratic republic, there is no expression that is more important. Michael talked about that in his wonderful opening remarks. Let me just add to the mix my very favorite Supreme Court quote on point when the court said that speech concerning public affairs is more than individual self-expression. It is the essence of self-government. And yet this is the target of this indirect censorship that Michael has spotlighted through government coercion of private intermediaries. And that is even more insidious than the old-fashioned direct kind of censorship. Thomas alluded to this as well, because it flies beneath the radar. To underscore this key point, I'm going to share one excerpt from Michael's book. And by the way, the excerpt illustrates that Michael's writing is as dazzling as his insights. He writes, "Overt censorship is very 20th century. Not only for legal reasons, but also for practical reasons, observable censorship is passé. What's more effective is self-censorship. It keeps unacceptable views from ever reaching the marketplace of ideas. It therefore leads to no noisy objections, no lawsuits. To censors, the silence of self-censorship is golden." You know, so many choice nuggets, sadly. Of course, as Michael fully recognizes, the First Amendment does appropriately protect government expression that falls short of coercion or collusion. The government may and should engage in what is usually called jawboning, opining, encouraging, and persuading. But the First Amendment draws a line for all of us between protected persuasion and unprotected threats. And that line applies to government too. So this is where that second key doctrine comes into play, entanglement. This is one of two exceptions. Thank you again, Marshall.
Nadine, I want to mention we have about 1 minute left.
This is one of two exceptions to the so-called state action limit on First Amendment rights. Under the state action limit in general, private actors are not subject to First Amendment constraints. But the Supreme Court has recognized two exceptions, and one of the exceptions is the so-called entanglement doctrine, and that is when private actors are not in fact acting on their own volition, but rather in close collaboration with government, in collusion with government, and under government coercion. And this is an argument that was only surfaced very recently, only a couple of years ago, and is now being tested in the courts, as Michael said. In my limited available time, I'm just going to make 2 points, if I may, Josephine. One is, as Michael and I have exchanged frustrated views for a couple of years now, this issue is for some reason not only ignored, but even disdained on the whole by lawyers and other scholars who are not on the right end of the political spectrum, which seems to be only a short-sighted, result-oriented focus on the fact that the current litigation happens to involve Biden administration officials suppressing critics of working with the social media companies to suppress critics of Biden administration policies. But the Trump administration was doing what it could to suppress social media views that were inconsistent with its policies. And whichever party comes to power in the future, unless the courts act to reduce, to eliminate this distorted concept of government speech and a distorted concept of entanglement that basically licenses the collusion. Free speech, Michael, you use very strong language about this, and let me quote it here. You say, unless the courts intervene, free speech in the United States faces extinction. So that was point number one, and very totally briefly, Josephine, point number two, because I can't end on a negative note. I am hopeful. Thank you. Thanks to Michael and my other colleagues here. Thanks to Michael's students, whom he saluted and to whom he dedicates the book. Michael has very, very stirring words about the function of free speech as the ultimate guarantor, not only of liberty and equality and democracy, but also as the ultimate guarantor of the closest approximation we can make toward truth and toward human rights and all the other good causes that censorship supposedly, but not in fact, redresses. So, Michael, let me quote one of the many stirring positive statements you make on that theme. The impulse is ever present to mistake personal preference for universal truth. It is the highest object of free speech to keep both the governed and the governors from succumbing to that temptation. Thank you.
Thank you so much, Nadine. My role clearly is to suppress everybody's speech. Bob, over to you.
Okay, thank you very much. I'm not an expert. I was delighted to hear from the experts. And I guess my role here is that when I was appointed to the Massachusetts Supreme Court in January of 2001, I met my predecessor who was retiring. It was the first woman who had been appointed to the Supreme Court of Massachusetts many years before that. And I was in her lobby and she says, you know, you will be taking the Oliver Wendell Holmes seat on this court. I said, what? So I have 20 books about Oliver Wendell Holmes on my bookshelves. And I was quite honored because he was, of course, on the Massachusetts Supreme Court and became its Chief Justice before he left for the U.S. Supreme Court. In any event, Professor Glennon's book was challenging for me. I'm not a social media user myself, believe it or not, and still get my views from 4 newspapers and the Associated Press every morning. But what a detailed, insightful, and timely book it is, providing insightful, and I repeated myself, providing a close look under the hood of today's marketplace of ideas and the symbiotic intertwining of social media platforms and agencies of the government, and the dangers to free speech that have arisen therefrom. I had no notion of this before my deep dive into the book, and I really enjoyed the journey. One of the points made which turned a switch on for me was the notion that the right to free speech includes the right not only of speakers, but of listeners in the marketplace. And that's absolutely true. And I really had never thought of it quite that way. By the end of the book, and after a bit of research, I suspected that Professor Glennon actually wrote the book to help the U.S. Supreme Court navigate through the issues in its upcoming decisions in Murphy versus Missouri and some others now pending before it. But before I go further, let me tell you a sort of a prophetic story from my own experience working with judiciaries in countries around the world. Most relevantly, my work in Turkey. In 2013, I was invited by the Turkish Judicial Training Academy to bring a delegation of American judges to Ankara for a multi-day discussion about free speech and free press under the US and Turkish constitutions. And I recall a conversation I had with one of the leaders of the academy shortly after I arrived. He pulled me aside and said, "Justice Bob," that was my name internationally, Justice Bob. I got that somewhere, but it stuck. Turkey, we use the same Oliver Wendell Holmes clear and present danger test that you use in your country. But what speech presents a clear and present danger of imminent harm here is quite different from the speech that presents such a danger in the United States. And he was quite right. For example, not long after our conference, it became clear that, at least from Erdogan's point of view, criticism of his leadership was deemed to create a clear and present danger to create or encourage uprisings among the Kurdish population in the country. And when posts on Twitter and YouTube began raising corruption issues in the government and Erdogan's family, Erdogan ordered access to Twitter be blocked, threatening to, quote, rip out its roots, and imposed severe restrictions on YouTube. Both actions were ruled to be violations of the Turkish constitution by the Constitutional Court, and thus began an insidious campaign to cripple the judiciary and destroy what was left of the freedom of speech and freedom of press in the country. In 2016, Erdogan ordered the arrest of almost 3,500 judges whom he and his government suspected might be disloyal to him, and seized their assets. And by 2018, there were more journalists in Turkish jails than any other country in the world. The lesson. The path to autocracy requires the neutering of two independent and interdependent institutions, the freedom of speech and the press, and the judiciary. These two institutions are indeed fundamental cornerstones of a constitutional democracy. As Justice Breyer has eloquently expressed it, a free press is necessary to narrate to the public what is being done by those in power, to provide them with the information necessary to vote and make other decisions in an intelligent way. An independent judicial power is necessary to guarantee the continuing existence of the condition precedent necessary for democracy, such as free press, free speech, and to ensure that those in power cannot, in practice, strip citizens of the freedoms that in principle are guaranteed by a constitution. I have to say, that was a wonderful quote that I have used often, because I have focused greatly internationally on this relationship, the independent judiciary and free speech. And they are critical components of a constitutional democracy. And I must say that an autocrat's, did I already talk about autocrats? I don't know. Autocrats' functions are to do away with both, or to cripple them so that they are no longer interfering with the government. My next story involves a book by Anthony Lewis. Now, I got to be a friend of Anthony Lewis because he was married to the Chief Justice of the Massachusetts Supreme Court, Margaret Marshall. And we spent lots of time together at various events. I love the guy. He was a journalist for decades following the U.S. Supreme Court, wrote a couple of great books, Gideon's Trumpet, Make No Law, and his last book was written in 2007. And I have it here. Freedom for the Thought We Hate, a biography of the First Amendment. And in going back and reviewing the book, I've actually given many talks on it, but not for a while. This is 2007. And going back and after reading Professor Glennon's book, looking at this book, what is so interesting to me is there's not a single mention of social media or social media platforms or anything of that sort. Look where we have come between 2007 and today. A whole new marketplace with new challenges. But one thing he did say, Professor Glennon has noted that courts need to step up to meet these challenges. One thing Anthony Lewis did say at the very end of the book, which I love, because it was so resonant, the truth is that bold judicial decisions have made the country what it is, and only that kind of judicial boldness, of courage, will preserve a free society in an age of international threats and governments ready to use them to advance their own power. Of course, democracy should not wait for the courts to save it. It needs to act. Both the courts need to act and we need to act in order to save it. I do love that. And I think I'm under my time, right?
Bob, you're amazing.
I just talk fast, that's all.
Fantastic. So I'm gonna actually throw things to the audience because we don't have a ton of time left. I want to take a few questions in a row and then give each of our panelists a chance to respond to whichever of them they like or to none of them and something else entirely in the grand tradition of panelists. If you've got a question, please raise your hand. I should have mentioned at the beginning, we are recording this to post afterwards. So if you're going to say something so provocative you don't want your name attached to it, then don't identify yourself. Yes, over here with your hand. Go ahead. I'm sorry, I can't even see who I'm pointing to. Yetta, go ahead. Were you raising your hand?
Yes, thank you. My name is Josephine Wolff. I'm a professor here, and I'm also here as president of the Faculty Senate with a couple of my esteemed colleagues. And I'd like to take it down a notch because I'm not a U.S. lawyer. I listened and I learned a lot. But what I would really like is some advice on what we should do when it comes to drafting, or if we should even draft a statement on freedom of expression and academic freedom. Because we've been discussing this for a long time. I know I have Brent here who's chaired our research committee for many years. And in the recent months, we've just seen so much focus on this and we are not sure how to proceed. And then I want to add to this complication also the demands on university presidents from donors that we have always had, but which I think in recent months have been very, very explicit. So even if we allow students and faculty to say anything they want in the classroom, which some universities do, as long as they don't insult an individual, still there might be a disconnect with what the presidents are asked to do. So advice, I have my pen here and I'm ready to take notes. Thank you.
A few questions. Okay, we'll come back. Do we have other questions? Otherwise I worry we won't get to more people. Yes, go ahead.
I'm Lang Law. I'm an undergraduate student here, and I want to preface this by saying I'm very appreciative of the fact that this work exists, especially in these times. But I would like to challenge what I think is a pretty fundamental assumption of the work, that social media platforms, as they presently exist, behave in the same way as a commons, or a marketplace of ideas. When fundamentally, every other sort of common space that has existed in any human society has been driven by human social interaction by basically by sociology rather than by computer algorithms that are barely understood even by the people who created them. And we've observed that the ways they've behaved have actively promoted people to segregate in many ways, including by which ideas they prefer and by the ways they value truth, which has led to a collapse in the value of truth in modern American society, and has also just led to much more vocal opposition to democracy because people are, I guess for a historical example, look at the force that was exerted by the entire American political establishment against something like the John Birch Society in comparison to the fact that QAnon, because it was able to be incubated in such a space that was so readily built for self-segregation to brew something like that, created it, and is now one of the driving forces behind a major American political party. And also, I mean, Mark Zuckerberg has basically ordered a pine box for the Fourth Estate at this point, which has also been such an important part of how any sort of common space, any marketplace of ideas works. So I'm wondering how we can even try to apply such that historical framework of how a marketplace of idea works to this modern issue, and if it needs to be adapted, in what ways can we do that in order to, preserve free speech properly?
Thank you. One more question.
Thank you. I'm Siranush, journalist, and here I'm a young scholar. So I have two questions, very short. So the first one is, do you think like free speech works more for people who have liberal, progressive views? And as a lecturer, do you feel like you are somehow restricted? Do you have this option of free speech when you are in working with your students? Like you don't, for example, face this kind of situation like 10 years before.
Fantastic. So a slate of really interesting questions. What should universities do? Isn't the internet different from what's come before? How does this work in the classroom? Does this favor people with certain kinds of politics over other types of politics? Nadine.
I wish I could answer all of the great questions, but if I have to choose, I'll go with number one because I'm an activist, and I am so grateful that you have a committee here that's working on a free speech policy. I'm a very active leader with 3 major academic freedom organizations that can provide just a treasure trove of resources. The Academic Freedom Alliance, I'm naming them in alphabetical order. The Academic Freedom Alliance, FIRE, the Foundation for Individual Rights and Expression, and Heterodox Academy. As a real coincidence, yesterday, all 3 organizations teamed up to advocate to every higher education institution that, among other things, it adopt a policy of institutional neutrality modeled on the famous 1967 Calvin principles from the University of Chicago. Beyond that, even more fundamentally, the Chicago free speech principles, which recently were updated and expanded last year by the Princeton free speech principles. And I think the process, which does draw a distinction, by the way, between what students and faculty members are saying in an open forum as opposed to what they're saying in a classroom situation or a professional situation. The standards, not surprisingly, are different. And I think while those provide useful models, there's a really wonderful experience that comes from each faculty, each university community, just using it as a starting point to re-examine and to take advantage of your own status as a private institution to decide whether you might want to amend or modify some of those starting point principles in a way that's specific to your own educational mission. So it's a wonderful educational experience for students and faculty members, but those are great starting resources.
Thank you. Thomas.
So I'll address the second question, which I really appreciated. And I think if I understood you correctly, you were suggesting that that social media platforms had an interest and perhaps a duty to moderate content in order to counter the results of algorithms that they had created and implemented. I hope I understood the question correctly. I thought the question was that these that it's different from just having a public space where everybody can come in and talk, and now you say, well, I'm not going to let certain people talk. I thought what you were suggesting was that the environment that is created in these social media platforms can amplify the most harmful voices, and that it's in the interest of the social media platforms and in the interest of society for social media platforms to understand that and to try to address it. And I agree with that. I mean, I think that that social media platforms have their own free speech rights and interests. I think they exercise editorial discretion. They create a community of people who communicate. And although they're different from a traditional media outlet, I think that they share some of those common features. And so I think that they have free speech interests in curating what that experience is going to be like on those platforms. I think where I would become most concerned, and really it's a kind of empirical question, is if any particular social media platform had kind of chokehold monopoly power, or if a cabal of a few had chokehold monopoly power, such that there really was technically the marketplace of ideas was open, but effectively it was closed to some people. And to me, that's an empirical question that I don't have the answer to. I did try to do some sort of very back of the envelope research before this session to kind of have an understanding of how many of the social media platforms have how many users. For instance, the law in Florida that bans, so it's either the law in Florida or the law in Texas that bans social media platforms from moderating content. It applies to any social media platform with over 50 million monthly viewers or users. I can't remember which. And I was curious, well, how many does that apply to? And I couldn't get the answer. Josephine, you may know the answer off the top of your head. You think there's only 3 that have 50 million monthly users? Okay, who are the 3?
YouTube, Facebook, Twitter.
Okay, but you can imagine if you made the threshold much lower, you might include the New York Times, which is a social media platform in some sense, because there's a comment section at the end of every article. In any case, I do think that the social media platforms have an interest in free speech rights. And I think where I would become most concerned is if I felt as though the market consolidated in such a way that there weren't real choices. And I don't know whether it's an accurate characterization of the social media landscape today.
Thank you. Bob,
What do you want?
do you have thoughts on whether free speech favors liberal politics?
In reality, or, in fact?
In fact.
Well, it shouldn't. If you read Michael's book, you would see for sure that there is a slant to this, depending on who the president is. But I don't know. I don't know the answer to the question.
It reminds me of the famous line by Stephen Colbert when he had his previous show that truth has a well-known liberal bias. Right? So if the truth is liberal, then free speech, if it's going to lead us to the truth. But I agree with Bob. Free speech should not have a liberal or conservative bias, because if it does, then it's undermining the whole point of the marketplace, which is that we can't say in advance which idea is true, a liberal idea or a conservative idea. We have to wait and see. Now, I'm all for people who have a particular political perspective arguing forcefully that their ideas are better, and I have ideas, and I want those ideas to prevail, and I want certain ideas to be marginalized, and I want to use the marketplace of ideas to accomplish that. But the government can't step in ahead of time. And I think, Michael, this is a point I think you make in your book, that whenever you're tempted to favor censorship of any sort, just imagine your nightmare scenario of someone in charge. I say this to my students sometimes, and I have to say, now this is just hypothetical, right? This is not a real, but imagine that your nightmare becomes president. Do you want that person to have the power to censor? And pretty quickly, people responded, no, we don't want censorship.
So, Michael, we've talked for an hour about your book. I want to give you the final word to respond to anything and everything you'd like to.
Thank you, Josephine. Well, first of all, thank you. This was an extremely illuminating discussion. I hope we can all continue this discussion in the future. Let me just respond quickly, because we're out of time, to two of the questions that were just raised. Is the internet a different marketplace of ideas than we have had in the past? And is it, as a consequence of the dynamic created by algorithms and bots and the like, less reliable? I think the answer to that question goes back to the point that Thomas Healy made earlier, and which I make in the book, and that is that the reliability of the marketplace of ideas is itself part of the marketplace of ideas. It's not as though we're looking at the marketplace of ideas as a petri dish in a laboratory and that we are disconnected from it. No. If the marketplace of ideas produces unreliable results as a consequence of the phenomena that the questioner raised, those results are discounted or rejected because everyone knows that these bots and algorithms are distortive. So my answer to the second question, which Jetta, the president of our university senate, raised, is, as Jetta knows, the same answer that Nadine gave. We should model our new free speech principles after the Calvin Report and the Chicago Principles, and adopt formally a position of institutional neutrality, affirming that the university is the home of ideas, not an advocate for a particular idea. I gave that advice to the president of our university. It hasn't been adopted yet. I hope that he does adopt it. Thank you all for coming. This has been a marvelous discussion.